When life gets unpredictable, preparation matters. In medicine, it's all about staying alert, ready for whatever comes through the door. On the road, it's no different. That's why Volvo designs vehicles to help anticipate risk, reduce harm, and protect lives. The Volvo XC90's advanced safety systems inspire confident decisions wherever the road takes you. The Volvo XC90, for life. Proud sponsor of the Pit Podcast. Learn more at volvocars.ca/safety.
The biggest question, the most important one, is the application or not of Bill 21 to English-speaking school. That's the issue, because the Superior Court said that the Bill 21, the prohibition to wear a religious symbol for teacher, should not apply to Anglophone school boards. And the Court of Appeal had a different opinion. So that's, I think, the issue that is at the very heart of the case at the Supreme Court of Canada. And more largely, some other group are challenging the whole Bill 21. They're saying that the bill shouldn't apply, including to French-speaking school boards and to all of the states. But I think that the most controversial issue and the one that will be debated very hotly is the one about English school board.
That's Guillaume Rousseau from the Mouvement Laïque Québécois. He joined us earlier in the program, reaction to the Supreme Court's decision to hear the Bill 21 case. And as you heard Guillaume say, English school boards really the most important part of this appeal. Let's go to Joe Ortona, chair of the English Montreal School Board, at the heart of that appeal. Joe, thank you for coming on this morning.
Good morning, and thanks for having me on.
So would you agree with Guillaume Rousseau's assessment there?
I agree with it in part. Obviously, Section 23, English school boards, the right to manage and control, is a very, very central and important issue that, the Supreme Court is going to consider, all of the arguments and at length, and take the time that they need, and hopefully continue to develop the constitutional principles around Section 23 for future cases across the country. But Section 28, gender equality provisions, is just as important of an argument, and it's going to be just as hotly contested. And the interesting thing about Section 28 is that because of the Section 15 gender equality provisions, there's very, very little case law and very little jurisprudence about Section 28. But Section 15 can be knocked down because of the notwithstanding clause, and Section 28 can't. And so that's the central issue here. So I think he's partly right, but I think Section 28 is as important as 23.
So Joe, various parts of Bill 21, they've gone through the two levels of courts, and the Quebec government has won at both of those levels. But are you saying here, in the Supreme Court of Canada, so much that so far has gone against the people against Bill 21, you think it's jump ball, and that the Supreme Court will go and open up the whole thing here?
Well, the thing is, the way the court system works, it's not a playoff series. It's not a best of three, and it's not because you lose in all of the instances in the lower courts that you can't win at the Supreme Court. It's not because you win in the lower courts that you can't lose at the Supreme Court. The Supreme Court decided to hear this case. Essentially, what it means is, look, there's an important issue here, one of national importance that could have implications, throughout the entire country, because other provinces may want to adopt similar legislation. The French minorities in other provinces may be affected in terms of, their right to manage and control their school system. It's a national question of national importance and a legitimate constitutional question that needs to be settled. And so what the court is saying is that they're going to hear all the, oral arguments and read all of the written submissions, and ultimately settle the case, because their decision is going to be final, and everybody's going to have to adapt to that reality whenever that decision comes.
So how do you prepare for this? How are you and the lawyers at the MSB, and what will be the work that happens now? I know we don't have a date yet, but what's the work that's going to happen between now and appearing before the Supreme Court?
Well, a lot of that work is already done. We're not reinventing the wheel. The arguments that we submitted, they're going to remain to be the same ones. Essentially, why we feel the law should be struck down, why we feel it's unconstitutional. The big advantage we have over everyone else is that we're fighting provisions that fall outside the notwithstanding clause. So we don't, the government can't use that shield to protect itself from the EMSB's challenges. And the only thing to add to what all of the hard work that the lawyers have done thus far is, why did the Court of Appeal get it wrong? So what were the errors in their interpretation of either the facts of the case or their interpretation of the Constitution that make it such that the decision should be overturned?
With Joe Ortona, chair of the English Montreal School Board, what were you thinking at 9:44 a.m. this morning, just before the ruling came out?
Well, not knowing is nerve-wracking, no matter how confident you are. I mean, I would say I was cautiously optimistic, but you never know what the ruling is until you finally hear it. So, obviously thrilled that the Supreme Court is willing to hear the case, and we look forward to, having our day in court and submitting all of our arguments. But it's a long wait, and I had my morning coffee and tried to wait as patiently as I could.
Can I ask you, Joe? I haven't seen maybe the groundswell of support from the other English school boards. I'm looking at the challengers here, the plaintiffs here, English Montreal School Board. I don't see any other school boards listed here. I wonder on that end. Do you expect now maybe that is going to the real deal Supreme Court, that maybe you'll get some, or do you want some more support from the other English school boards?
Well, just because other school boards are not officially a party to the case doesn't mean that they don't support the cause. Mm-hmm. The Quebec English School Boards Association did get involved and make representations at the Court of Appeal stage. The English school boards do support our challenge of Bill 21, and many people in the community support our challenge of Bill 21. Ultimately, every school board is independent. I respect that independence. They choose whether they want to actually make representations before the court if they choose to go that route. I certainly would welcome anyone who does, but they support the cause. Very much so.
Joe, we're going to have to leave it there. We got to get this morning is just all breaking news. Got to get to some more news. I want to thank you so much for coming on, Joe. We'll keep track of this, okay?
My pleasure. Thank you.
Joe Ortona is chair of the English Montreal School Board.